Supreme Court is now in session. The Honorable Chief Justice F. Philip Carbolito, Chief Justice presiding.
Good morning, everyone. Will the clerk please call the case?
This is Supreme Court case number PRM 06-006. Amendments to Miscellaneous Rule 7.1 of the Local Rules of the Superior Court of Guam, Relief from Disabilities. Appearing to present the amendments for promulgation is Judiciary of Guam Staff Attorney Daniel Menching. The panel consists of Chief Justice F. Philip Carbolito, Associate Justice Robert J. Torres, and Associate Justice Catherine A. Merriman.
Thank you, Mr. Menching. Before I recognize you, the order in which we are going to proceed is you will address MR 7.1, Relief from Disabilities, and then you will then go ahead and proceed and present on the amendments to MR 1.1.5 regarding compensation to our private attorney panel. Thereafter, I will recognize the clerk of court who will then present on our court records retention policy. So at this time, Mr. Menching, you are recognized.
Thank you, Mr. Chief Justice, Justice Torres, and Justice Merriman. May it please the court. The Supreme Court has before it amendments to Miscellaneous Rule 7.1 of the Local Rules of the Superior Court of Guam, which governs Guam's Relief from Disabilities program. Under both federal and local law, certain individuals are ineligible for firearm ownership due to prior adjudication of mental incompetence. Individuals who are subject to such adjudication are entered into the National Instant Criminal Background Check System. Miscellaneous Rule 7.1, which was enacted by the Guam Supreme Court in 2010, creates a relief from disabilities program in which an individual who has previously been adjudicated to have a mental defect may petition the court for relief from that determination for the purposes of the individual's ability to purchase a firearm. Having such a program is a requirement for Guam to be eligible for certain federal grants. The current version of Rule 7.1 does not provide a mechanism for granted petitions to be entered into the relevant national databases which process firearm background checks. Such a mechanism is a requirement for relief programs to make a jurisdiction eligible for grants. The proposed amendments will bring Rule 7.1 into compliance, while also making minor technical adjustments and adding provisions which are common in programs from other jurisdictions, such as providing the Attorney General's office with notice and an opportunity to object. The proposed amendments were sent to the Guam Bar Association for comment on February 25th, 2022, with a comment period of 2 weeks. No comments were received. On behalf of the Administrative Office of the Courts, I now present these proposed amendments and ask that they be adopted and promulgated as presented to become effective immediately. Thank you.
Thank you, Mr. Menching. Does any of the justices have any questions for our staff attorney?
I don't have a question, but I'd also add that this is a recommendation from the CJAC committee in order to improve our access to criminal justice records and give persons with disability the opportunity to seek getting a gun permit again if they wish. And it's recommended by the CJAC committee.
Thank you, Justice Merriman. So we will conclude the presentation on the amendments to MR 7.1. For the record, I ask the clerk just to call the topic for the next presentation.
This is Supreme Court case number PRM 06-006. Amendments to Miscellaneous Rule 1.1.5 of the Local Rules of the Superior Court of Guam, Indigent Defense Rule. Appearing to present the amendments for promulgation is Judiciary of Guam Staff Attorney Daniel Menching. The panel consists of Chief Justice F. Philip Carbolito, Associate Justice Robert J. Torres, and Associate Justice Catherine A. Merriman.
Thank you. Mr. Menching, you are recognized.
Thank you, Your Honor. Mr. Chief Justice, Justice Torres, and Justice Merriman, may it please the court. The Supreme Court has before it amendments to Miscellaneous Rule 1.1.5 of the Local Rules of the Superior Court of Guam. The proposed amendments will increase both the hourly rates and the maximum compensation amounts for court-appointed attorneys. The amendments also create additional categories of compensation so that maximum payments will be more closely correlated with the seriousness of the offense. The amendments further clarify some issues that have been brought to administration's attention by the Judiciary's Financial Management Division in their experience processing payments under the current rules, such as compensation in cases where multiple attorneys are appointed and how to compensate attorneys appointed in juvenile special proceedings cases, both of which are unaddressed in the current version of the rule. The amended rules also affect interpreter pay by increasing the rates for registered non-block hearings and by clarifying that all interpreters paid on an hourly basis will be compensated to the nearest 1/4 fraction of the hour. The proposed amendments were sent to the Guam Bar Association for comment on February 9th, 2022, and comments were accepted until February 17th, 2022. 4 comments were received from the bar, 3 of which argued that the proposed rates were too low. The 4th comment stated that the judiciary should further increase interpreter pay and hire full-time Chuukese interpreters. Contrary to this suggestion, the judiciary's current staffing pattern shows that the judiciary currently employs 3 full-time Chuukese interpreters, including David Welly, who leads the judiciary's interpreter program. In addition to the comments received from the bar, the administrator of the court submitted a statement of support for the amendments, explaining that 10 other jurisdictions have been surveyed and that the new rules will put Guam equal to or ahead of almost all of those jurisdictions. The administrator of the courts also explained the funding source for appointed attorney pay and the limitations on those funds. And while acknowledging the concerns of bar members who provided comment, finds that increases above those contained in the proposed amendments would challenge the judiciary's its funds. While the many variables involved in compensation under these rules make it difficult to predict the exact financial impact of these amendments, the judiciary's Financial Management Division has reviewed the amendments and projected that there will be roughly a 30% increase in expenditures if the amendments are put into effect. A new form, which corresponds to the proposed rules, has been prepared for attorneys to complete and submit to the judiciary's Financial Division for processing a payment under the new rules. On behalf of the Administrative Office of the Courts, I now present these proposed amendments and ask that they be adopted and promulgated as presented to become effective May 1st. Thank you.
Thank you, Mr. Menching. First of all, any questions to the staff attorney by any of the justices on the bench?
I would just comment that one of the suggestions was that a judicial officer review all of the vouchers. And I just want to say, as a former judge who had to do that, it takes a lot of time, and I don't think it's a good use of a judge's time to do that. I just would like to make sure that if an attorney has a concern about how his voucher was treated, that there is a place for some kind of review of his concern or his complaint.
Yeah, I can address that. Under the current rules and the new amended rules, there is a process for.
So that's my question, Mr. Menching. How is?
Sorry, we had a little delayed transmission there, but Attorney Menching, you are recognized to address Justice Merriman's question.
Thank you. Upon an attorney going above the amounts, the maximum amounts, there's a process for them to apply for extraordinary fees, in which case it is first flagged by the Courts Ministerials Division and then sent to the administrator of the courts, who will review it along with staff attorneys to determine whether or not extraordinary fees are appropriate for that case. And it is the role of the Administrative Office of the Courts to review that, because unlike the Judge, the Administrative Office of the Courts does have access to the fund and can review the fund to see if it's healthy, and also defer to the Administrative of the Courts, Christina Baird, if she has anything to add to that.
If we can just hold on for a minute, Justice Merriman has dropped out in reference to our virtual courtroom, and I'd just like to give her the opportunity to try and log on again because it's her question that is specifically being addressed. And Hannah or Trina, if you could just contact shelter.
Chief Justice, Justice Merriman indicated she will try to call in and connect by phone.
All right, we will just give her a few minutes and then hopefully she'll be able to at least listen to the proceedings.
Hello. Hello?
Yes, Justice Merriman, we can hear you. We just suspended and did not proceed when you were logged off. So your question is in reference, you stated your experience as a judge, that it's not it may not be an efficient use of a judge's time to review an attorney's request for review of his or her billing. And the administrator of the courts was going to add some comments after Attorney Menching had stated a response to you. I'm not quite sure if you had caught any of Attorney Menching's reply to your question.
Yeah, no, I did not.
All right, just for the record.
If he could repeat it.
Yes, I will ask him to do that, and then I'll recognize the administrator of the courts if she wants to add any other comments. Attorney Menching.
Thank you, Your Honor. I had explained the process under the current rules and the new proposed rules is that upon a attorney billing above the cap in a particular case, they can then petition for extraordinary fees. And that petition is reviewed by the administrator of the courts and by the staff attorneys to determine whether or not or it's reviewed by the administrative courts with input from the staff attorneys to determine whether or not extraordinary fees are appropriate in any given case. And then I defer to Christina for additional comments.
Ms. Baird, for the record.
My other question is, what happens if an attorney's voucher is discounted or changed and the amount they're paid? Who do they go to? Is it the same process with the attorneys?
I'm sorry, I didn't understand that question. Can you repeat your question again, Justice Merriman?
Yeah, maybe it's not happening now, but there used to be occasions when, for various reasons, the total amount requested was not paid. And then the attorneys wanted to try and get that amount that wasn't paid restored. Is there a process if they have that situation?
And I take it you mean that not paid because it's in excess of the cap?
No, under the cap. It might be they say that the record doesn't show a hearing was held that day, or it was too much time spent, or something like that. I don't know if they still do that, but back in my day they did.
Ms. Baird, would you like to respond to that question?
Thank you, Chief Justice, and good morning, Justice Torres and Justice Merriman. In my experiences, we have not had anything of what you've described, those type of circumstances. The initial billings are first brought to C&M, who identifies the type of the type of case, and then that determines caps. Then the attorneys file with FMD, and their FMD will review and audit what they're filing for. But I've never seen where FMD or even the administrator of the court's offices denied anything that didn't exceed the caps. So for the past 2.5 years, nothing like that has occurred. As to the other question that you asked, I would like to add that under the new proposed changes to the miscellaneous rule, there is a statement there, a sentence there, that the Superior Court judge does have input into whether exceeding the cap is warranted. It doesn't require the judge to do the review, but they do have input under these rules changes. I would also point out that before, under the old rule, there was no gauge or factors that guided the administrator of the courts or the Superior Court judge as to what factors would warrant exceeding the cap. Under these proposed rules, there are factors that were researched and taken from other jurisdictions and added in. And this provides guidance to all parties, the counsel that is filing, also the judge if they're looking, and the administration's offices that are reviewing the billings that are coming in. And I did want to point that out, that we do have laid out factors that we follow when we look to a request from counsel to exceed the cap. And those provides us some guidance under these proposed changes. Thank you, Your Honors.
Any
Thank
further?
you. Then I'm satisfied there's a
All right. Thank you.
procedure for attorneys to resort to. Thank you.
Thank you. Thank you, Justice Merriman. Justice Torres, any comments or questions for the staff?
I have no questions.
All right. Thank you. Thank you, Attorney Menching and Attorney Barrett. You may just continue to stay on. And I will ask the clerk to please call the final matter that is before the court this morning.
This is Supreme Court case number PRM 06-006, amendments to miscellaneous rule 6.1 of the local rules of the Superior Court of Guam on records retention. Appearing to present the rules for miscellaneous rule 6.1 for promulgation is Superior Court Clerk of Court Danielle Rossetti. The panel consists of Chief Justice F. Philip Carbolito, Associate Justice Robert J. Torres, and Associate Justice Catherine A. Merriman.
Attorney Rossetti, you are recognized at this time.
Thank you, Your Honor. Mr. Chief Justice, Justice Torres, and Justice Merriman, may it please the court. On behalf of the Subcommittee on Rules Revisions, I am here this morning as a committee member to present proposed amendments to Miscellaneous Rule 6.1 of the Local Rules of Court on records retention. The Records Retention Committee is a subset of the Rules Revisions Committee chaired by Justice Torres. Members of the Retention Subcommittee also include judiciary staff attorneys, the clerk of courts for the Superior and Supreme Court, and other key judiciary staff. The rule on records retention originally existed in an appendix to Title VII GCA of the Guam Rules of Civil Procedure as Rule 93. In 2006, through promulgation order, the Guam Rules of Civil Procedure and Rule 93 were moved from Title VII to the Local Rules of Court. Rule 93 is now Miscellaneous Rule 6.1. Over the last year, the committee met regularly to discuss amendments to the retention schedule and also worked to get 7 GCA Section 7120 on the disposition of court records amended. The committee looked at retention schedules for various court jurisdictions as a model. The proposed retention schedule that is before the Supreme Court provides a schedule for both Superior Court and Supreme Court records. The schedule divides records that existed prior to 2011 when we did not operate under the current electronic case management system, also known as JustWare, and those records that were filed from 2011 to the present. Technology continues to advance and courts across the nation continue to improve the efficiency of cases through technology improvements. Electronic filing continues to expand, and in many courts, e-filing is mandatory. Our courts have implemented e-filing for both the Supreme Court and Superior Court and hope to expand the Superior Court case types in the near future. The proposed schedule includes all case types filed in the Supreme Court and Superior Court, as well as other court records such as court audio recordings and jury records. The current retention schedule requires that all records be microfilmed before destroyed. The proposed schedule will allow for the retention of the records in a digital format before destruction, and similar practices have been adopted in other court jurisdictions. Notice of the proposed rule was sent to the Guam Bar Association on January 24th, 2022, and written comments were accepted through February 3rd. Notice of the virtual promulgation hearing was filed on April 4th, 2022, and sent via listserv to the GBA members. The committee received 2 comments during the comment period. The first comment concerned the retention of land registration cases, specifically retaining the original certificates of title issued by the Department of Land Management and filed in a land registration case. The attorney recommended that land registration paper records be kept indefinitely and not destroyed. The second comment was on the retention of restitution cases. The concern was the time period for collection of restitution by a defendant and the proposed destruction of 1 year. The attorney recommended that the records be kept indefinitely or until restitution is completed. After speaking with the attorney about the comments, I clarified that court records are not destroyed if the case remains active. And therefore, that addressed the concern that the attorney brought to the committee for the proposed schedule that is before the Supreme Court. At this time, Your Honors, the Retention Subcommittee requests that the Supreme Court adopt and approve proposed Rule 6.1 on records retention for Supreme Court and Superior Court records to be effective immediately upon promulgation and approval by the Supreme Court. And I will make myself available for any questions that the panel may have. Thank you, Your Honors.
Any questions or comments do we have for Attorney Rossetti?
I just want to make a comment, Chief Justice. I want to recognize the hard work of the Records Retention Subcommittee as part of the rules of civil procedure. And this is a new local rule. Both the clerk of the Superior Court, Ms. Rossetti, the clerk of the Supreme Court, Hannah Gutierrez Arroyo, staff attorney, former staff attorney, and now Deputy Director Serge Kenga, MIS Administrator Rob Robigo, Carl Paris from the clerk's office, the compiler of law, Geraldine Cepeda, and Mary Grace Rosandino were all valuable members of this subcommittee and contributed to an extensive review of our record retention policy. And so I appreciate all of their efforts. And it is now, and as you remember, Chief Justice, this really started with the pushing to get a change in the legislation, which we had worked on for almost a year before the legislation finally came to fruition. So it's good to see, and we're now going to, be bringing ourselves and providing more efficiencies and economies for our branch as far as our record retention policy now.
Thank you, Justice Torres, and I join you in your comments, but you left out the sponsor of that legislation, Senator Mary Torres. So we want to recognize her for her efforts in helping us achieve the amendment to the law that's applicable to our retention policy. So I want to thank all of you for presenting. Your efforts help in reference to achieve a more efficient and responsive judiciary to the people of Guam. And so if there are no other questions, the court will take the matters under advisement. We will deliberate and then issue an order in reference to the various requests in a promulgation order that we will then respond to in reference to the various requests that have been made before the court. But we want to thank you. I want to thank you for all your efforts. Any concluding comments? There being none.
No, thank you.
Okay, I'm sorry, Justice Merriman. I couldn't see you, but we can hear you very clearly. And so if there are no other comments, the court will now conclude its proceedings, and we now stand adjourned.
Thank you. Bye-bye.